One concern I run into with a parent who is not in the military, but their spouse is they want primary parenting time because of the instability or the unknown with the military spouse. So they generally are trying to get primary custody or parenting time in that situation, and they have the concerns as far as what that would look like. If the parents are in the same exact location, it's more than likely that a court is going to go towards a 50-50 schedule. That's not necessarily written in law, but a lot of courts kind of start off with that basis, and then they start veering off of that depending on the other circumstances and other possible endangerment to the child with that parenting time schedule. Now, for the non-military parent who wants to move out of state, once again, they have that same concern as far as wanting to become the primary parent due to, once again, the instability with a potential military job or the instability of that schedule. In those situations, that client does have strong arguments, primarily dependent on what their own schedule looks like and what other connections that they have. So the factors that the court will look into is family support, connections to the community, connections to friends, the connection to the child, and all that sort of stuff. Usually the non-military parent has good arguments as it relates to the stability, the connections, that sort of thing, if they are living in an area with other family members or other close family friends. Now, if that non-military parent is moving to a location where they have none of that support, well, then they don't really have those strong of arguments. The primary thing that they would have arguing for them then is the stability as it relates to their home schedule or their work schedule. But once again, that's going to be case specific and dependent on that individual's actual job.